Now, I would like to continue with the second part of our first chapter, Introduction to Legal Reasoning. The second part is talking about the art of legal reasoning. But before coming into details of this part, first of all, I would like to raise the question to you. What do you understand by saying that the art of legal reasoning? Why legal reasoning is an art? So legal reasoning is different from math. Math plus 1 plus 1 must be 2. But in legal reasoning, you see that although the same legal issues are solved, but the language used, the arguments constructions, and the way that they lead and they cite or they prove the matter are different from judgments to judgments, and maybe different from judge to judge as well. So therefore, legal reasoning is an art. For example, I can give you an example so that you can easily understand. For example, I give you an exam questions. Do you think that with the same exam questions, I receive back 30 the same answers from 30 students? No, actually not. The same questions and the similar ideas of answers, but the way they represent their answers are different. If I receive the two answers are exactly the same, what do you think? They are copied of each other's, right? So it's similar applicable to legal reasoning. Although the same legal matters, the same proofs and evidences, the same rules and norms, but the way that the judge reasoning things, prove things, or analyzing things, the language used and structures and the style are different, may be different. So legal reasoning is an art, and this art is built up with the language. Language is a professional tool of legal reasoning. And in terms of legal reasoning, it's normally issues in the form of writing. Therefore, we have to know that in legal reasoning, there are two types of writings: predictive writing and persuasive writing. And planning, rewriting, and work habits of the individuals also influence to the quality of this art of legal reasoning. First point, language is a professional tool of legal reasoning. So we already know the role of language in general. In our human being's life, language is the great development of human beings, and it helps to distinguish us with the other animals, transfer the knowledge from generations to generations, right? So in legal profession, the role of language is even more important because all of the norms are expressed in language. So now, in general, the role of language is that a means of communication. It helps to convey ideas and meanings, exchange ideas, express what is going on in the mind. And the thoughts of our human beings are explained and known through the language. In legal profession, language is our professional tool because the laws are written in language, our advices are written in language, right? So our professional tools. Therefore, there is some importance of these professional tools. If your readers or listeners' attention is drawn to the obscurities and other forms in your writing or your presentation, you and your client will suffer for several reasons, right? So therefore, why we have to develop a very good professional tool. First, the reasons for losses or for influences is that the typical reader begins to resist and may not finish reading your papers because they, lawyers and judges, are busy people who do not have time to wade through very difficult writing. The second reasons for your clients or you yourself suffers is that the reader is tempted to consider you unreliable, unprofessional, because mediocre use of the language implies general mediocrity as a lawyer. Thirdly, busy readers may misunderstand what you are trying to say, and if they misunderstand your thoughts or your arguments, so your clients must be suffer. So we move on a little bit about characteristics of legal language. Did you see any differences in terms of legal language and the ordinary language? Can you see? Yes. So, in our legal language, we might use ordinary words with specialized meaning. For example, you know the word suit in general meaning, the custom, right, the suit. But what does it mean by the term lawsuit? Is it a custom of law? No, right? Lawsuit, law case. And also in the legal language, if you read some papers written in English or even in French, they use also Latin words and phrases. I can give you an example. When I departed to Australia for my PhD research, so I have to read books about criminal law area, and I found those terms mens rea and actus reus. Do you know what does it mean by mens rea? It is a Latin word. It means guilty mind. What about actus reus? It is also a Latin word, and it means the conduct. And you see, because French language, France used to dominate many countries when they were the powerful country, so their language also influenced the other countries, so that you can find normal French in some of the papers too. Another characteristic of legal language is that in some papers they can claim the words used with precision. For examples, I can see several contracts and between party A and party B, and the word contract is in the capital letters. So it means that the term contract is not general, but specifically for this agreement, these transactions between party A and party B. That is the way the people claims the words with precisions. Or they even can use in some of the ritualized word forms. For example, if you see the oath, someone making the oath in front of the judge or the jurors, you will see that they say, I promise to tell the truth, the whole truth, and nothing but the truth. You see these kind of ritualized word forms. And sometimes, different from the first point, people claim the word precisions. Sometimes that lawyers try to not point out exactly the meanings of something, so they say, my argument is reasonable. So the term reasonable may be overexploited. Now my questions to you, can you clarify the role of language to lawyers? And can you view it from different aspects? Now I come to the second point of legal reasoning as an art. It's about writing. So you see that in legal writing, there are two styles that is called predictive writing and persuasive writing. And you might guess, what does it mean? Because from the word predictive and persuasive writing. So first of all, predictive writing is served for two purposes: to advise the clients of their legal issues, or to advise the clients to plan the litigations. Or you cannot advise the clients, but you communicate with your partners or your clients to plan litigations. So I can give you an example. Bob have just purchased a washing machine from one of the store which is not far away from his house. And he signed the contract and made it to be installed in that afternoon. And when the machine was installed, fixed up, and tested for the trial, it was broken out at the first time of testing because of the water van of that machine was broken. Bob was completely unhappy, unsatisfactory, because he really wants and he spent money to buy the original one. And he thought that the supplier, the seller, must replace the new one for him. But technicians, people said that because the problem is quite minor, just a water van, so they can replace only the water van and then the washing machine will work properly. Bob didn't agree with the solutions recommended and suggested by technicians, and he argued with them. He also came to the managers, but they didn't fix it up. He come to you as a lawyer and would like to have his problem to be solved. He wants the original new one, and this broken machine must be replaced. Now, you have to answer his questions whether he has the rights to have the new machines replaced. That is, your answers are written to him. So you see, you just advise Bob about his problems based on the facts and based on the rules. The facts is that his contracts, the guarantees, and also the broken water van and the dysfunctions at the first time, etc. The facts happen, and also the rules in the civil law areas. And then Bob and the customer service people cannot agree. Bob wants to bring his case to the court. So now he asks you, and he wants to know, he must know about the litigation process. So the second kind of writing that you're providing to your Bob clients is the letter to plan litigations. So you see, predictive, it just predict the outcome of Bob's issues, predict the process, the steps of litigations if Bob brings his case to the court. So this is where the cases and purposes where predictive writing is used. And the very popular form of predictive writing is the legal memorandum, Memo. In short, this is a very common type of predictive legal analysis. It may include a client letter to ask you and to describe their own matters, and also it may include your legal opinion. Functions of predictive writing. What is it? Predictive writing predicts the outcome of legal questions by analyzing and the authorities, the rules governing the questions, and the relevant facts that gave rise to the legal questions. It also functions to explain and apply the rules, the authorities in predicting an outcome, and ends with the advice of the experts or recommendations. It serves as record of the research done for given legal questions. This is also important to us as lawyers too, because when you provide the work to your clients and then you give your legal advices, but then maybe the outcomes are not as wishes, and your clients might turn back to argue with you, to sue you. So all of your legal advices are written down as a proof to research and to prove that what are true of your legal advices. And also when you receive the payment from the clients, so those kind of your writing also serve that's your work, you already done what had been asked. The second type of writing in legal professions and legal reasoning is persuasive writing. Persuasive writing is kind of comprehensive style of writing. It is rhetorically stylized, and it must be framed as an argument. And you know that in the predictive writing, you give a very neutral analysis, you just predict the outcomes. But in the persuasive writing, it argues for one approach to solve the matter. It never presents a neutral analysis. Now we turn back to the example of Pop case. Now you come to the court. Pop believed in you and trusted you and would like you to protect his rights in front of the court. So you have to submit your proof to the court to prove why Pop has such a right to have the replaced machine. So in this way, you have to persuade the judge, to persuade the court. Therefore, you just have one approach in order to solve the legal matter. So the questions, what are functions of persuasive writing? Persuasive writing is used to persuade a deciding authority to favorably decide the dispute for the author's client. And it's usually submitted to judges, but sometimes if you bring your case to the arbitrators or mediators, it also used to submit to them, to persuade them to favorably to decide for your case. And sometimes it's also used to persuade the others, such as the media, in order to involve them into solving your case. Sometimes you have the meeting, the negotiations with the other parties to solve the problems. So it also, persuasive writing also serves to persuade the disputes opposing party. The third point in our second part is that planning, rewriting, and work habits also influence the quality of art of legal reasoning. You see that every one of us can have different habits. Some persons are well organized, while the others are disorganized. Some are complete, but the others are not complete. Someone have a very clear ideas and thoughts, but the others are vague and obscured. Someone are very concise, but the others are not. Someone has their ideas connected with each others in a very forceful way, but the others are not. So these kinds of things can influence your writing, influence your exercising judgments, and influencing your papers. Therefore, you see that planning, rewriting, and work habits are all influenced. Now, I would like you to answer the following questions and do the following things. First of all, I would like to ask you, which work habits do you think that are useful to legal profession? And which work habits should be avoided in legal profession? The second thing is that from the answers of these questions, I would like you to mirror yourself, to look at your portrait, and to write down what good work habits do you have and what bad work habits do you have. And from that list of good and bad habits of yourself, I could like you to develop a plan to build up good habits and try to diminish your bad work habits so that you can be better with your legal professions, right? So I didn't want to show those because I would like to wait for your answers. So that is the second part of our first chapter, the art of legal reasoning. In the next clip, I will come to the next part, effective legal writing style.